It's the same with, Teams calls. Your microphone's off, your cameras on. I just, when will it ever stop? And the trouble is with the microphones, you're as the last one to know that your microphone isn't on. But there we go. Yes, I had the accompanied site inspection this morning, so I did view from Johnny Gate Lane, and I was pleased that the weather forecast that I saw on TV this morning was not accurate, and there wasn't. Section of, and the council provided with me with a Google Street View image of the site from that vantage point, but before the development was actually carried out. So by way of comparison, I went higher up the slope on Johnny Gate Lane, but as far as I could see, you couldn't see the site from other sections of Johnny Gate Lane because of topography, because of hedges, banks, dry stone walls, etc. There may be points along there we could see it, but I didn't notice any. But from the site itself, obviously, I could see across the slope, so I could see across the valley to where there are some buildings on the date at that point for resumption. So, and also, given the absence, for example, of proofs in relation to appeal A, the absence of a statement of common ground, there was an opportunity for some case management, and I took that opportunity. So gave some directions, for want of a better expression, for the progress of the case thereafter, and that was all explained in the email that was sent out on the 1st of September. So what I'm saying is, clearly, the fact that that event, that the inquiry opened on that day, was at least partly down to me, but there are reasons why I did that. Right.
In relation to costs, you heard the discussion. For whatever reason, I don't blame the council. I didn't get a copy of the amended costs claim last night. Mr. Leithhead has sent it to me this morning, and it's come through. So I got that at 11:22. I haven't even opened it. I was doing something else. And what I want to make sure is that I understand the nature of the claim, and I also need just to make some corrections if, based on what you just said.
Yeah.
So what I propose is, I mean, I can open the email now, but probably better. Let's do closings, I would have thought.
Yeah.
Then Mr. Leatham makes his application. I'll hear what that is. I'm then going to seek a bit of time. Depending on what's said, that may not be, I may not need very long. I may need more time. I have a printer. I would make some changes to the written response that I've got. So the response that I amended last night was amended based on what I now know about the original claim. So I haven't seen the amended claim, and I certainly haven't been able to deal with it.
That's fine.
Okay. I said this was it's only slightly amended. It was sent to it was sent to the right email address about 5:15, but he's got it now. And I've clarified that the substantive costs are the whole way through the inquiry. I think it's probably was perhaps my fault, but there was a reference to 6th of September. Of course, the Ground C appeal was removed after the 6th of September, so I thought it was clear it was going beyond that date. But for the avoidance of any doubt, the substantive claim is up to the present day.
I just would like to hear that it's
Absolutely.
obviously, and I want to read it.
Yeah.
So I think
That's
it doesn't
fine.
stop us doing closings. But
Yeah, that's fine. And just before we get off the topic of costs, I still haven't worked out exactly how the application should be dealt with. I haven't had an opportunity to speak to anyone in the costs and decisions team. It's not the first time I've had linked appeals and where one of the appeals is withdrawn. But I think it's the first time I've had a situation where it's so difficult to disentangle one from the other in terms of costs implications. So I will need to speak to the cost decisions team, but the easiest way is for me to hear everything I need to hear and then speak to them about how it should be dealt with. It's just as I said yesterday, when it comes to writing the appeal decision, there won't be an appeal decision on appeal A. There'll be nothing more than a reference in appeal B to the fact that there was appeal A and it's been withdrawn, because there's nothing for me to determine. And really, following on from that, there's nothing for me to determine in terms of costs. It's for the, as I said, really strictly for the Secretary of State. But I've just got to work out how that works in practice. As I said before, when I've had it before, it's been quite straightforward. You can say, well, appeal A is gone, everything to do with appeal A, the costs. We'll deal with that, but there's a bit of an overlap here, which is a bit more tricky. So it may all become clear to me after another night's sleep, but we'll see. Right. So if you're ready, Mr. Leafhead, we can just hear your closing submissions. No, in enforcement is the appellant who gets the last. Yeah. Yes.
Thank you, sir. These are a bit of feedback.
maybe if you put a microphone.
That better? Yeah, that better. Thanks, sir. These are the closing submissions on behalf of the council. The council's case is set out in the various documents submitted, and in particular, proofs of Mr. Julian Hawley and Ms. Joanne Edwards. Appeal A. As Appeal A was withdrawn by the appellant immediately before the inquiry commenced, no submissions are made in relation to that. Appeal B, Ground A. Mr. Hawley has explained why the appeal should fail under Ground A, and that's in his proof and his rebuttal proof. Numerous weaknesses of the appellant's case are summarised at paragraph 33 of the council's updated cost application, to which I'll turn in due course. In outline, the appellant is a long way from demonstrating that very special circumstances exist to justify granting planning permission For the substantial inappropriate development, he chose to develop in the Greenbelt within a special landscape area, which is valued landscape for purposes of paragraph 174 of the NPPF. You so identify the following main issues in your agenda for the inquiry: the effects of the new garage and unfinished building on the openness of the Greenbelt, the effects of the new garage and unfinished building on the character and appearance of the locality within an area of primary landscape sensitivity, and see whether any harm by reason of inappropriateness and any other harm would be clearly outweighed by other considerations, so as to amount to the very special circumstances required to justify the proposal. First, the impact of the unauthorised buildings on openness. As you, sir, will be aware, the courts have identified a number of matters which need to be taken into account when considering openness. These include spatial and visual aspects, the duration of the development, and its remediability. The new garage. The new garage is a significant development with the volume calculated to be 387 metres cubed. It increases the footprint and volume of built development on the land to a substantial extent and has a substantially negative effect on the openness of the Greenbelt in spatial terms and the degree of activity likely to be generated, such as traffic generation. In visual terms, the new garage significantly increases the mass of development, which is highly visible from the main public highway, especially during winter and spring months. It's highly visible both within the site and from immediately adjoining land and permanently developed land that was previously open absent of any built development. This results in substantial harm to the openness of the Greenbelt in visual terms. Harm to the openness of the Greenbelt would further be caused by the domestic activities for which the new garage would be used, including regular vehicular movements. As there would be no reasonable prospect of the land being returned to its original state or to an equivalent or improved state of openness, there would further be harm. The permanent building would always be visible, and so any impacts upon openness would endure for the long term. Unfinished building. In spatial terms, the unfinished building with the volume calculated at 587 metres cubed, and that excludes the dormer windows, so the front, rear and side elevations, has an even greater negative impact on the openness of the Greenbelt. In addition, it further significantly increases the mass of development which is visible from the land, from adjoining land, and is highly visible from the adjacent main public highway, especially during the winter and spring months. And it raises the height of the building considerably above the pre-existing situation. Consequently, it has a substantially negative effect on openness in visual terms. Like the new garage, the unfinished building is a substantial and permanent structure, which also results in harm to the openness of the Greenbelt. There's further similarly no reasonable prospect that land would be returned to its original state or to an equivalent or improved state of openness. The permanent building would always be visible, and so any impacts upon openness would endure for the long term. Conclusion on openness. For the reasons above, the unauthorised building has a substantially negative impact on the openness of the Greenbelt, both individually and cumulatively. The harm to the openness of the Greenbelt furthers the effect that the purposes of the Greenbelt as set out in NPPF paragraph 138 are undermined, and particularly the apparent urban sprawl, and by the way, there should be an and by the way in which they encroach into the countryside. There's 2 of the 5 points there. The impact of the unauthorised buildings on character and appearance. Landscape character. Landscape characterisation is the process that defines what makes an area unique and different from another area. As set out in the technical support documents produced by the County Council, primary landscape areas in the county fall within areas of multiple environmental sensitivity, which are areas of landscape that have been identified as being sensitive with respect to a range of environmental data sets. The site is within a primary landscape area. Primary landscape areas are those with the highest sensitivity and which are most likely to be negatively affected by change or development. These are areas where the landscape remains intact, both visually and structurally, have strong historic and cultural identity, and contain many widespread semi-natural habitats with the associated linkages appropriate to the character of the area. The site is further identified as being within the Derbyshire Peak Fringe and Lower Derwent character areas, and within the wooded slopes and valleys character type. The relevant landscape character description document explains the features of this character area. The key characteristics can be summarised as upland, undulated ground rising to moorland, slopes are moderate to steep and steepen along stream valleys, permanent pasture for sheep and dairy cattle, densely scattered small to medium ancient woodlands and secondary woodland on steeper slopes and along streams, densely scattered hedgerow trees, irregular field pattern bounded by mixed species hedgerows, dry stone walls, a widespread defining a more regular field pattern, network of winding lanes sunken on steeper slopes with rocky banks, dispersed sandstone farmsteads with stone slate roofs, The majority of historic buildings are constructed of local sandstone, traditionally roofed with stone slates. Farmsteads are dispersed throughout the landscape, though there are occasionally clusters of farmsteads and cottages. A strong focus on the protection and conservation of their environmental and built environment assets. In terms of the local plan, landscape character and primary landscape sensitivity in particular is relevant to policy SDC3, which states the development will only be permitted where it would not cause significant harm to the character, quality, distinctiveness, or sensitivity of the landscape. Finally, as already stated, the appellant accepted that the landscape in which the site sits is valued landscape for purposes of paragraph 174 of the NPPO. Impact of the unauthorised buildings on character and appearance. First, a new garage. As mentioned above, the local vernacular is sandstone farmsteads with stone slate roofs. The new garage is constructed out of timber, which is not representative of garages in the locality, which tend to be stone or a mixture of stone and timber. Even agricultural buildings are not typically constructed with timber. There's a typo there. Timber buildings are more typical for equestrian development. Not only is the building out of keeping with the wider area, it doesn't even fit with the host dwelling, Brinwood house, as you have seen in your site visit this morning, sir. As to the impact of the building on the landscape more generally, it is built in an elevated position on the site and is visually prominent when approaching from the south, especially in the winter and spring months. The building is further visible within the backdrop of rising land and scattered woodland forming the ridgeline. The new garage represents urbanising built form which pushes development east across the contours towards open pastoral land. It harms local distinctiveness as it is an alien and substantial domestic outbuilding in an agricultural landscape. The size of the building is significant as it fails to respect the scale, proportions and character of the surrounding properties or landscape. The building is located a significant distance from the dwelling, with the effect that it lacks any intimate association with Brinwood House, as would be expected with a domestic garage. And then the unfinished building. As already stated, the local vernacular is sandstone farmsteads with stone slate roofs. The unfinished building is constructed from timber, part stone cladding, and has large areas of glazing. In design terms, it is an awkward and unusual arrangement of timber-clad gables, floor-to-ceiling glazing panels, and dormer windows. It harms local distinctiveness caused by an alien and substantial domestic outbuilding. Building size, design, and appearance are neither representative of functional agricultural buildings within the dispersed farmsteads or domestic outbuildings, which possess an element of subordination. The building further represents an urbanising built form which extends development east across the contours towards open pastoral land and within the agricultural landscape. Whilst houses in the immediate vicinity are typically more modern construction and are of a typically more modern construction design, they're intimately contained. The new garage and unfinished buildings result in an unacceptable sprawl of development, which impacts unacceptably on the site and its surroundings. It appears as a new isolated dwelling in the countryside. Built in an elevated position on the site, the unfinished building is visually prominent when approaching from the south, especially in winter and spring months. It is visible within the backdrop of rising land and scattered woodland forming the ridgeline and open pastoral land below. The harm caused by the building is compounded by the fact that it was obviously unfinished, as shown in the photograph at page 8 of Ms. Hawley's proof. In relation to a deemed application under section 1771, planning permission is granted in respect of the matters stated in the enforcement notice as constituting a breach of planning control in whole or in part. The effect of this is that what was not completed at the time that the enforcement notice itself cannot be completed by ground A. In case of that, as we discussed, is Arnold. In the case of the unfinished building, USO could not lawfully require completion, even if you were minded to do so. Just pausing there and departing the text briefly, the purposes of the building have been described in different ways at different times. As I understand it, it was a party room at one stage, and now it's a sort of golfing room. You would have seen on the site visit, they look like material that would be used for flooring. The appellant claims it's finished and that there's no intention to put another floor in. Looking at the building, it does seem that that's unlikely, but that's for you to form a judgment, sir. The appellant has suggested that it could be completed without planning permission, but it certainly is not clear how it could be, and no plans have been provided to demonstrate this. Finally, the size of the building is significant and fails to respect the scale, proportions and character of the surrounding properties or the landscape. And then finally, conclusion on landscape impact. For the reasons above, the building has a significantly detrimental effect on local landscape within the area of primary landscape sensitivity, which is contrary to both national and local policy. And then the fallback position arising from permitted development rights. The appellant's case on very special circumstances is largely dependent on his alleged fallback position arising from permitted development rights. While the appellant's abandoned his initial claim that the unauthorised buildings benefit from permitted development rights in a Class E, he argues that other buildings could be within the curtilage of Brinwood, I was supposed to say Brinwood House, not Brinwood Wood. Getting late by that point, I think. Lancashire, the Lancashire appeal. In support, the appellant relies on an appeal decision in Lancashire mentioned by Mr. Telford in his evidence. However, the appellant's been unable to provide the appeal decision, and the council has similarly been unable to locate it. Notwithstanding this, it's apparent from the article supplied by Mr. Telford that the circumstances of the two appeals are different. The Lancashire appeal involved parked vehicles, whereas the present matter is concerned with two large unauthorised structures with a greater negative impact on the greenbelt and on the local character and amenity. The parent buildings would always be visible, and so any impacts upon openness will endure for the long term. In any event, only very limited weight could be granted to an appeal decision that is not before the inquiry and cannot be located. Limitations of Class E. A further difficulty in the appellant's argument is that the unauthorised buildings do not come within the limitations of Class E, for reasons including that they do not come within the size restrictions. And there's two separate paragraphs, and for that, so you're invited to see section 10 and 11 of Mr. Hawley's proof, even though it's within what was Ground C. The effect is that the same buildings could not be constructed within the curtilage of Brinwood House and benefit from the permitted development rights under Class E. So a conclusion on the fallback position of very special circumstances. But the most that can be said about the appellant's fallback position is that some sort of buildings could lawfully be built somewhere in the curtilage of Brinwood House, though no plans exist as to what the buildings would be or where they might go. Further, the amount of engineering work that would be required to level the land would further prevent the appellant from relying on Class E. And then where development in the greenbelt is inappropriate by definition, the planning permission may only be granted where the harm by reason of inappropriateness and any other harm is clearly outweighed by other considerations, so as to amount to the very special circumstances necessary to justify the development. Overall, the appellant has not come close to demonstrating very special circumstances. The ground has no merit. Ground F. The significant materials used in the construction of the unauthorised buildings were brought onto the land solely for their development. The retention of these materials for an unspecified and unknown purpose is unreasonable. Thus, the requirement that they should be removed goes no further than that which is necessary to remedy the breach. Consequently, the appellant's appeal under Ground F should fail. Ground G, after the inquiry was resumed on the 1st December 2022, the appellant indicated that he sought to rely on Ground G. The council's position is simply that the notices provide adequate time in order to comply, but it's relaxed about a modest increase in this time period if the inspector are of the view that it is warranted. For all the reasons above and in the council's evidence, you are respectfully invited to dismiss the appeals. So before I pause, I'll just turn to my side if I may.
No, maybe just following on from this morning's site visit, if I may, what's appropriate to do, sir?
Well, I don't know what you're going to say, but it's not really appropriate to have further evidence at this point.
No.
But I do want to ask about what you said about Ground F, because Mr. Hawley indicated yesterday that there were a number of respects in which the requirements could be lessened. So
I think it wasn't. Well, Mr. Hawley might be better placed to explain that. I think there was a question about drafting of the notice.
yes, so
So it's not really lessening them, but saying it in a different way, perhaps.
well, the one was to remove the requirement about hard standing.
Yeah.
Now, I take it, I understand that that's because Mr. Hawley never intended all of the hard standing to be
Yeah.
removed, but on the face of it, the notice may
It
suggest that it does.
I think it's about clarifying the notice rather
Yeah.
than changing its requirements.
It doesn't really matter how I
No.
characterize it.
Yeah.
But
No, I just wanted to. I thought. I mean, the council's not rowing back from anything, which it's just not said it as well as it might have done.
okay. Um, Thank you very much. Yes, Mr. Hardy. Thank you.
Thank you.
Very much. And then before I turn to my text, obviously have the right of response, and we'll make a little bit of feedback, just make some observations. I think the overarching point is that, and it's one that has characterised the council's case, the closing submissions with respect are just trying a little bit too hard. They are exaggerated and in some ways overwritten. And just to pick up on the detail of that, landscape character, if we can turn to paragraph 19, where the landscape character description for the area is set out. I mean, the underlying character appraisal came in very late, fair enough, but come on, this is a house with a garden. There's no credible suggestion that this is a an L&V character case involving key characteristics in the broader area. 21, the local plan. Interestingly, there's no suggestion that we breach SDC 3, where that policy states the development land permitted where it wouldn't cause significant harm to the character, quality, distinctiveness, or sensitivity of the landscape. It's sort of floated, but it's not suggested that we do breach that. And of course, we don't. I mean, the idea that there is significant harm from these buildings in the residential context that they're in to the character area is it just doesn't stack up. And in 22, there's reference to the valued landscape. I come back to that in closing. Yes, it's accepted that it's a valued landscape, but of course the policy test is preserve or enhance. And you got the evidence yesterday from Mr. Telford, which is that we're not making we're not putting it too high. We're saying that there is no harm, therefore there's preservation.
Well, just a moment there. Isn't it preserve and enhance? Let me just double check. Negotiate my way through my finding system.
Yes.
Protect and enhance.
Protect
sorry, and enhance.
Yes, but my view is that you can't. I mean, otherwise, why would you have both as a requirement? Because if you've got to enhance in every case, you don't need to protect, do you?
Well, I suppose, yeah, I mean, we could end it because the old debate with conservation areas and so on, whether it's preserve or enhance.
That's the South Lake case, of course.
Preserve,
no harm is preserved.
Preserve or enhance is definitely sufficient to preserve. But I suppose that there may be circumstances in which, notwithstanding the general value of the landscape, you have a site which is pretty poor and it doesn't take much to actually, and you don't want to preserve it. You've got the opportunity to enhance.
A matter for you. I mean, there's no
Right.
allegation that in fact that there's a breach here of paragraph 174. I'm just picking up it by way of response, but we say, look, in the residential context, there is no harm to the valued landscape. I don't need to go further than that. Impact then of the buildings. Only been on site this morning. This doesn't ring true with what you've seen. I suspect it's been written. I know Chris and Mr. Lee.
Sorry, which paragraph are you referring to?
So in the section which starts 23 on the new garage, I mean, I suspect were written before Mr. Lee said I hadn't been on site. Now that we've all been on site, this does not ring true. So 26, impact of the building on the landscape more generally, visually prominent when approaching from the south. It's not. I mean, it's discernible, but it's absolutely not visually prominent. That's exaggerated. 28. The garage harms local distinctiveness as it's an alien and substantial domestic outbuilding in an agricultural landscape. I mean, again, come on. 30. The building is located a significant distance from the dwelling. It isn't, as you saw this morning. It lacks any intimate association. It's a garage. It's a sloping site. It's a garage which serves the house. Unfinished building. Paragraph 32. There isn't an objection to this scheme in relation to design, but in design terms, it's an awkward and unusual arrangement. That doesn't seem to take the matter any further. This is about spatial development, not about the design, which may not be to the council's taste, but that's by the by. 35. Houses in the immediate vicinity are typically more modern construction and design. They're intimately contained. Well, that's exactly what this property is. You can't see it. That was agreed really yesterday. Again, third line up from the bottom, built in an elevated position. The unfinished building is visually prominent when approaching from the south. Now, it may be accepted that it's more discernible than the garage, but we don't accept it's visually prominent. You can pick it out, but it's not prominent. Would indicate something of greater magnitude than that. 36. Harm caused by the building is compounded by the fact that it was obviously unfinished. I think what's become obvious is the council have got a problem with this, and in my view, it's a problem with understanding. And Mr. Leithhead went off his written submissions today to say, well, there were building materials on the sort of flooring materials and so on. Looking at the law, anything that's internal to that property does not need planning permission. Anything which is done externally has got to have a material effect on the external appearance and character. The building in planning terms is finished. No, it's not the finished article. It's not the building as you would just go and use it tomorrow, but that's not the planning question. And the work that's required, the filling in of those the gaps at the back, whether that's I haven't had time to check the plans, but whether that's glazing or whatever, you are not going to be able to discern a material effect on the character and appearance of that building from enclosure on that side. It is finished and was finished at the time of the enforcement notice, and that's the sensible, pragmatic view. In terms of flooring materials, Mr. Leithhead's point was a poor one, because you need to floor the ground floor. It's not a case of there's some sort of suggestion, oh, we might be putting in a first floor. Absolutely not. But you need to put floors down on the ground floor. So that was, again, I think, an example of that exaggeration and over-reacting.
May I just and if necessary, Mr. Leithhead can comment, but obviously you'll get the last comment on this. But in terms of material effect on the external appearance, what do you say? Because you've referred there to enclosure of the rear, so the northern elevation, whatever that's going to be, whether it's glazing or whatever. And I mean, having heard what's intended for the use of that building, and given that there's lots of insulation material and so on, inevitably it's going to be enclosed. Otherwise, there's kind of no point in the insulation material apart from anything else. But when assessing materiality of external appearance, what do you say is and I don't want this to obviously get into evidence, but I think it is a matter of law really as well. What do you say is relevant?
It'll be a matter of fact, wouldn't it, for the decision maker? But that to me would be the structural elements of the building. So that would be that's framework, that's roofing, that's fenestration.
But so I was thinking more in terms of where you can see things from. How relevant is that in terms of material?
That's a factor which can be taken a bit like change to landscape character, whatever is, you've got to, it's perception, isn't it? But where do people perceive that from? I'm not saying that there is an objective test as well, but I think you could place weight on the fact you just aren't going to see. If you put glass, I genuinely don't know what's going on the back, but if you were to say put glazing panels, nobody's going to see that at all. It's going to be of no, it would not be seen from any vantage point or indeed private viewing area, given where that glazing or whatever it is on the plan. But in terms of the test, materiality, it is a matter of fact and degree, but it is so minor in relation to the structure of that building that, in my view, in planning terms, you wouldn't need planning. And even if you did, then of course, plan permission to finish it off. I mean, that would be there's so much of that building that's completed that you can obviously only grant consent for what's done at the time of the enforcement notice. But it's something I come back to in my closing submissions.
I commented yesterday on that eastern gable end, which was part block, but that's been clad now with timber. Isn't it?
Yeah. So I mean, there are bits and bobs, but even if you are going to put, stone tiles or whatever it is, in my view, that does not mean the addition of one stone tile that therefore has a material effect on character. But it's got to be more than, a sensible view taken of that, and therefore the principal elements of that building, and they're all absolutely there. So our view is that you could finish that without plan permission.
So I'll come back to you. But did you want to say anything, Mr. Leithhead, about this question of material impact on external appearance?
Well, so other than what was already said in the roundtable session, no, Mr. Hardy doesn't know how the building is going to be finished. He's submitting it's obvious. It isn't obvious to me how that building could be finished without affecting the external appearance.
So my question was more not so much about what's going to happen on that elevation, but how significant it is in terms of whether it's. We all know, for example, that let's not complicate this, but if you can't see it from public vantage points, is that relevant to the question of whether there's a material impact?
No.
Bear with me. Well, the reason I couldn't remember the name of the case, but it's Burrows Day versus Bristol County or City Council, 1996. In summary, the works to materially affect external appearance, the changes must be visible from a number of vantage points and material to the appearance of the building as a whole. Materially affecting the external appearance means an impact capable of having some effect in planning terms.
Yes, I was aware of that. And therefore, there's a difference in law. It's one of the cases which I'm going to submit. So I might say the council's wrong in law on that.
Yeah, I've still got to interpret that and apply it. But
of course.
That's why I was asking the question. That I think it's not entirely irrelevant that you, if you can't see it from public vantage points, it doesn't refer to public vantage points, but this is a number of vantage points.
It's implied that the change, I'm looking really from the planning encyclopedia, it's dealt with at 55.17 p. 55.17. the issue is whether certain works to a listed building constitute development requiring planning permission. The works included provision of a lift shaft housing, which involved alteration to the roof and placement of windows to the front elevation of the building. The court held that the works did not constitute development. It was not sufficient merely that work should affect the exterior of the building. That's what they should materially affect the external appearance. This implied the change was visible from a number of normal vantage points. Visibility from the air or from a single building would not be sufficient. It's going to involve a planning judgment from you. So what can be said is there are no plans before you as to how that building could be completed. I mean, we have no evidence on oath from the appellant about it's a very tall for a bungalow, or however it might be described as single story building. You need to form your own view on that.
Yeah, whether there's one or two internal flaws, I'm not sure is particularly relevant to material impact effect on the external appearance.
There are a number of gaps in the outside of the building, I think, on sides, even the side that faces towards the right.
Yeah, the side that faces east, it's not glazed, is it?
Some of it's part glazed. Yeah, there's a sort of narrow, shallow openings which aren't glazed, and then some of the main windows aren't glazed. But I don't know. Maybe I was wrong to assume. I was assuming those narrow, long, rectangular openings would be glazed as well, but I don't. Perhaps I shouldn't have assumed that. Okay. Anyway, it's just that point of principle about.
So seeing as you called, I'm later just to correct a factual point. I perhaps didn't express myself as clearly as might. I said that it was contrary to local and national policy. We are alleging a breach of SEC 3, and in fact that's in the notice itself. So which you'll see at I'll just get it. It was up, it's gone. That is at paragraph 4 of the of notice B. It says the development is therefore contrary to local plan policies GS2, GS6, H11, and NE2, contrary to ELP policies SS9, SS10, LC5, and STC3, and contrary to various NPPF policies as well.
Yeah.
Thank you, sir.
Thank you. Right, sorry about that diversion. But
Right, I mean, I'm slightly concerned about the council having another go, but there we go.
well, I was going to the thing about whether it was a breach of ST3. I had noted that the council had said that Mr. Leith had said in closing that it was a breach of local and national policies, but I had forgotten about the reference in the enforcement notice itself. But that's a fair point.
Also, I mean, the council clearly had been applying the wrong test, because you got a clear answer from Mr. Leith that it wasn't relevant. And Burrows Day, of course, says that it is in terms of materiality. So whilst that then was softened to it being a planning judgment, it's clear that if that has informed the council's judgment, then it's wrong. So in this case, there aren't views. And anything that was done on that back elevation wouldn't be seen from vantage points, and in planning terms that building is finished. Going back to the closings then of Mr. Leithhead, there's reference to the Lancashire appeal in his paragraph 43 onwards. I'm afraid it's missed the point. The transferable principle from that appeal, you don't need an appeal to make the point, but what is clear from the reference is that rather than have an open air parking use, it's better to put the vehicles in to contain them and contain the visually. And in this case, you've seen the hard standing and the number of vehicles, and we'll come back to that in my own closing, but that hard standing is excluded from the enforcement notice that will be used to park those vehicles, including equestrian horse boxes, RVs, and so on. So the point of the principle, or the reference, is to the beneficial effect of putting vehicles inside a purpose-built garage. Limitations class E. Limitations class E, paragraph 47. Again, misses the point really. The effect is that the same buildings couldn't be constructed within the curtilage of Brinwood House and benefited from the permitted development rights under Class C. Well, you just have the point is a qualifying building. So, you know, the advice absolutely, as you've heard, would be to submit a clopwood, but the metrics are understood. So it would be a modified building, which then maxes out those Class C rights. So the proposition is the buildings, they absolutely got that building, but a modified building absolutely can and would. In terms of 51, overall, the appellant has not come close to demonstrating very special circumstances. The ground has no merit. So sort of sounds to be borrowed from a kind of court pleading. Of course, the ground's got merit. We've been discussing it for a day and a bit. Council may disagree, but it's just the flavour, I think, of how the council, Mr. Leithhead, have approached this. So those are my comments in relation to what he's got to say. If I can turn to my own closing submissions, then it's unfortunate that it's really following this theme that the enforcement proceedings bear the hallmarks of heavy-handedness on the part of the council. And despite protestations to the contrary, the mask slipped a little bit yesterday when Mr. Leithhead expressed eagerness to start separate enforcement proceedings against the existing hard standing, which Mr. Hawley, it now turns out, had missed out of the current enforcement notice. And you recall, it was very sort of an excited voice. Well, you know, it would be a material consideration if we start enforcement proceedings. Mr. Hawley was also keen to take into account lawful extensions to Brinwood House, apparently on the basis that he thought it got too big already. There was certainly what he had to say was pregnant with that type of sentiment. And that was never an appropriate thing to do. Heavy-handedness isn't a planning matter in and of itself, but what it does do is help to illuminate what the appellant would identify as a persistently overplayed hand in terms of assessment and approach. These proceedings, it's worth saying, are very considerable distress and upset to the appellant and family, to the point where the appellant didn't feel able to attend the proceedings yesterday. It should indicate something. Must have indicated she come if the inspector is required to attend. There's already a real sense that council has singled them out for differential treatment. And of course, the council is under a duty to act dispassionately and in the public interest. It's not clear.
There wasn't any evidence of how other people have been treated differently.
You've not seen the correspondence. I mean, you don't, I'm not going to trouble you with it. But
Okay, all right.
So, you know, it's not a planning matter as such, but there is.
Yeah, don't worry about it because it's not, you know.
It's not personal. It's an issue, no?
I will be considering whether the development is acceptable or not whether other people have been treated differently.
Yeah, absolutely. Yeah. It's not clear to the appellant whether Ms. Leithhead was not briefed properly or whether Mr. Hawley didn't know, but it's a matter of considerable regret that the council refused to meet the appellant to discuss a constructive way forward. Clearly, you've got the relevant correspondence. When reminded of that correspondence, Ms. Leithhead attempted to say, well, look, the council had taken the view that it wasn't worth meeting. Well, that wasn't the point. Mr. Telford spoke to Mr. Purcell, as he's encouraged to do by national planning guidance, to try and narrow the issues and reach an acceptable compromise. And what the council did was shut up shop. And the appellant says that a sensible way forward could be negotiated. At the very least, a discussion should have been had. And as a result, here we are. Some of that's the council's own making. Planning, of course, morally neutral. Whatever the council thinks of the appellant person of these appeals should be determined in a normal way, as of course they will be. So there's no question. Absolutely, as we went over yesterday, they will be, but they should be. Appeal A, in discussion with the appellant on Wednesday the 29th, first time that I was able to take instructions, instructed the occupant of Brinwood Lodge had recently decided to pursue a romantic relationship, setting up home. As a result, I was going to be vacating the property, and as a result of that reflecting on that matter, the appellant reasonably came to the view Appeal A no longer served any purpose, so Appeal A was withdrawn, and that has shortened proceedings. So Appeal B, grounds of appeal, grounds A, F, and a newly invoked ground G. Having now heard the evidence, the appellant submits the following. It's common ground, Brinwood House, Brinwood Lodge, are seen only in distant views to the south and are viewed with a high hedge and rising land to the north, there forming a backdrop. It's agreed the property isn't visible from Millthorpe Lane on the public right of way. It's only visible from New Road to the south, where any views are broken through substantial hedgerows and mature trees. It's agreed that both buildings are set into the bank that forms the northern boundary of the site. It's indicated that the oak framed and oak clad buildings will weather into a silver grey finish. They're recessive. The buildings sit in gardens which are to be landscaped, and their appearance will be softened further. The appellant accepts, we've already touched on this really in one of the points in response, but the appellant accepts that the locally designated landscape is valued landscape. However, it doesn't really take the council anywhere because of the agreed lack of visual effects and absence of indirect character effects. So these appeals are dealing with buildings within a domestic curtilage. It's not a case about landscape and visual effects on a valued landscape. The council doesn't really contend that it is with any conviction. At the very least, the buildings preserve the valued landscape, no conflict with that policy.
What do you mean by agreed lack of visual effects?
In terms of the visual enclosure, the view shed. You can't see it from the.
Okay, well, the council's case is that there is a visual effect. That's what I just.
Yeah, they do, but when you come to it, you can't see it. It's common.
It's just the word agreed that I'm.
What is
querying.
what is agreed? You indicated yesterday, being on the site visit right at the outset, that it's only seen a distant views to the south. Really, my point 1 and point 2. Only seen a distant views to the south view with the high hedge rising land to the north, forming a backdrop. Property not visible from Millthorpe Lane or public right of way. NE 112612. It's only visible from New Road. So those are. Whether or not they then constitute a breach is a matter for you, council say they are, but the actual extent of the visual effects is agreed, seems to me. We are not disagreeing. We are not disagreeing, as I understand it, in any way about the locations, the viewpoints from which you can or cannot see.
So it's the agreed extent of visual effects rather than the agreed lack of visual effects.
Yes, so I suppose the view shed, where the visibility, the discernibility of these buildings is not in disagreement. That is an agreed position. What you then do with those views which are available is obviously a matter for you. And council say there's a breach of the policies. We say absolutely not.
All right, thank you.
So I hope that's clarified.
Thank you.
Clarified that. The garage in what's been described as unfinished building, albeit see it later, you've got my point, you know what's coming on that, but are separate buildings and they should be treated as separate entities. Both have different characteristics, functions, and result in different types of effects. One may be found to be acceptable, even if the other is not, vice versa. Separate and detailed, that should be assessments that aren't need to be carried out. It's accepted, of course, both buildings are inappropriate. Development in the greenbelt for paragraphs 149, for purposes of paragraph 149. However, properly applying the NPPF, you still got to determine how much harm there is to the greenbelt before applying substantial weight to it, as of course is required by paragraph 148. Any assessment of potential harm to the greenbelt by reason of inappropriateness will need to consider impacts on openness, both spatial and visual, and relative harm to the 5 purposes of including land within the greenbelt. It's only when that exercise has been done that substantial weight can be applied to the quantum of definitional harm. Of course, to do this, so this needs to be added any other harm resulting from the proposal. Court of Appeal dealt with that in the Red Hill Aerodrome case, of which should be very familiar. This is Patterson being overturned in the Court of Appeal. When it made plain the very presence of any other harm in the then wording, it's not changed, but in the then wording was sufficiently and deliberately set apart from harm to the greenbelt, so as to imply that it was dealing with harm in the non-greenbelt context. So that will be visual harm, heritage harm potentially, or landscape or traffic harm, or whatever it is. In the case of both buildings, the quantum of definitional harm and any other harm has been exaggerated by the council. This matters because it feeds directly into the very special circumstances equation. If there's a lower degree of harm, then the other considerations need to do less work to clearly outweigh such aggregated harm. As part of its cost claim, council seemed content to submit the case on ground A in Appeal B was hopeless. And I already made the point. I mean, that's just it's untenable, given the full day of inquiry time which we spent discussing just that. Whatever the outcome of these appeals, the appellant retains his permitted development rights within Class C. So I've got reference to Mansell and Tonbridge. Lord Justice Limbom conferring the legal considerations in determining materiality of a fallback, and you indicated you're fully familiar with this, but just to summarize them, basic principle is that for a prospect to be a real prospect, it doesn't have to be probable or likely. Possibility will suffice. no rule of law that in every case the real prospect will depend, for example, on the site having been allocated for the alternative development in the development plan or planning permission having been granted for that development, or on there being a firm design for the alternative scheme, or on the landowner or developer having said precisely how he would make use of any permitted development rights available to him under the GPDO. In some cases, that degree of clarity and commitment may be necessary, in others not. This will always be a matter for the decision maker's planning judgment in the particular circumstances of the case in hand. The clear desire of the landowner to develop and maximise value of the site was sufficient to demonstrate a real prospect to the Class Q GPDO fallback position in that case. Well, here on challenged evidence, the appellant has a clear desire and obviously the financial means to maximise his use of permitted development rights. So whatever argument there might be about demarcation of curtilage, there is curtilage, of course there is, and the appellant will construct Class E buildings in it. Now the legal advice that now that I've got involved will be to apply for a clubhood before starting to build again. It's a realistic fallback position which will be exercised by the appellant. And whilst the appellant has not yet applied for that clubhood, that is not a prerequisite. So we are absolutely within the foursquare within Mansell and Tonbridge. You don't need to have drawn up plans. You don't need to have applied for your clubhood. What you do need to show is clear desire. And that is absolutely evidenced in this case. The landowner will be building Class E buildings. So the buildings are constructed of such expensive materials that they will be used. By reason of wooden construction, the unfinished building can be modified to meet all qualifying criteria. It's not for me to speculate, but you can take a view in relation to taking the legs off. It's obviously on a slope, but you can take the legs off. You can modify one of the window openings or the apertures on the hillside. You've got a door. Seems to me perfectly straightforward to do that to meet qualifying criteria. Now, whilst the appellant doesn't need to prove the point at this juncture, potential uses for the unfinished building include an indoor digital golf range, digital shooting range, and cover for vintage and performance cars.
I will say that obviously I've just got to make the judgment, but I've said yesterday that I didn't have sort of expert evidence about modification. But when I look at that unfinished building, for example, I find it very difficult to see how you could reduce that by 2 meters in height and call it a modification. It would be a completely different building.
Well, it doesn't
function in a completely different way.
What-
It's supposed to be used as a garage and so on. Golf, virtual golf, and clay shooting. If you took 2 meters off, you'd virtually remove what you might describe as the lower floor, lower story.
But I mean, the answer is no. If you just change the pitch of the roof, I mean, it doesn't need to be.
Well, the suggestion was that because it's a timber frame, you could basically just cut off part of the timber frame. What I'm saying is what you just indicated, that you change a lot more than just the timber, the height of the legs on the timber frame.
The important thing is for the client. I mean, well, the important thing in planning terms for this decision is that you have to be satisfied that there is a clear desire to use the Class E rights. That, to my view, is absolutely the case here. So the important point or the important thing from the client's perspective is to reuse the very valuable materials. That's the oak, to use as much of that as you can. So whether that is by cutting off the supporting structure, or whether or not that is removing the roof and lowering the pitch. I spoke to I'm not going to give evidence on it. You will have to form a view, but it doesn't have to be that building.
But all I want to be clear about is what it is I'm comparing, what's there.
You are comparing.
So I appreciate that there will be permitted development rights.
Yes.
There will be a curtilage, whatever that is, and whatever is constructed will have to comply with the limitations in the PD rights.
Yes.
But in terms of comparing the impact of that with what's there, I'm trying to build a clear picture of what that might be. And what I'm saying to you is I can't see on the evidence that it's just that building but lower.
Right. I don't have plans. We don't have plans. I haven't had time. Maybe I would, if I'd had time to to take instruction on that. We could have put some things. I do have some plans, but I'm not going to start putting evidence in now. But all you need to know is that those materials are so valuable to the landowner that they will be used to maximise Class E rights. So whether or not that is with a reduced pitch, whether that is by taking off some of the height or combine out of the supporting frame, or a combination of both, it is going to be using those materials. And so the point of comparison, so we say, is you don't have a precise plan, but Mansell and Tonbridge says you don't need to do that. It's for you to envisage as best you can a building with oak, with a tiled roof, with some fenestration, but at the maximum metrics that that Class C would allow. I don't think I can put it higher than that. I do not have a plan to say it's going to be this. I do know that talking to the client, that he's spoken to the carpentry.
Are we getting into evidence now?
Well, all I'm saying that there are conversations have started. That's all. I'm not going to put plans in it. Absolutely not. Right. But conversations have started about what you would do. Right. A house of premium quality is my 15. House of premium quality like Brinwood House can expect to have a commensurately large garage to house a variety of vehicles, including equestrian vehicles, motorhome, sports car, and various types of motorbikes. Now, it was obvious on the site visit that this particular landowner has a passion for cars and expensive cars and gizmos and all, but leaving that aside, even if it was, of course, this is a decision that's made into the future, a future occupier of a house, which happens to be the most expensive in the postcode, is going to expect somewhere to park cars, Range Rover, horse box, whatever it is. That is absolutely, that would go with that type of property, even if you are discounting the quads and all the other things. So applying relevant case law and professional judgment, the area red is the curtilage of Brinwood House. We say that's supported by the investigations carried out by the council in 2015 in alleged unauthorised earthworks, formation of the pool, basement, room, and pond, all of which were within the curtilage. But we say you don't need to go that far as definitively identifying curtilage. I noticed the council's pulled back from that a little bit in its closing. It's not asked you to do that. It's sufficient to give full weight to the fact that Class E buildings built out to the maximum metrics allowed by the qualifying criteria will come on the site. And it's, not beyond, it's not that, the curtilage is not that big. It's obvious there is curtilage, and I think we'll just leave that to you. But for planning purposes and for the test which has been set out in Mansell and Tonbridge, we think you've got enough to form a view. A comparison can be drawn on this basis. As Mr. Telford indicated, the current buildings have been designed to work with the existing topography. Can't be seen from the surrounding areas other than the limited points which you've noted, but Class E buildings in different locations over which the council would have no control actually may be more harmful. So it doesn't, maybe that actually you move and you make it worse. Have to form a view on that. In the case of the garage, as Mr. Telford said, the fallback position is that a multitude of vehicles will be parked on the hard standing, which we now know was excluded from the enforcement notice. And as you will have seen today, that's a reasonably substantial bit of hard standing. It can accommodate a number of vehicles. That's clearly less desirable in Greenbelt than parking vehicles within a high quality, well-designed garage. They'll be visible from the south across the valley where vehicles will be more conspicuous than the garage. The garage is a material improvement over an open parking area which already exists as part of the curtilage. Under ground A, planning permission can only be granted with breach of development control delays in the notice. Council stated the wrong test during the session. Internal, I think we've dealt with this. This is the point about finishing off, so you probably don't need to read that. 20 then, as a result, the fallback positions could take place anywhere within the land edge red. Current siting and design of the buildings most appropriate location with the least visual impact, and we say that should carry significant weight. Any determination that very special circumstances exist, of course, that's a matter for you alone. There's no prescribed list. And in the particular circumstances here, the degree of harm to the greenbelt resulting from definitional harm plus any other harm is extremely limited. The material considerations relied on by the appellant, which particularly the fallback position, are sufficient to clearly outweigh such aggregated harm. And counsel, we again, just repeating myself, exaggerated the harm and unfairly denounced the fallback. So we're doing the opposite, aren't we? They're exaggerating the harm, saying no weight to the fallback. We're saying actually, let's look at it sensibly. Harm has got to be looked at dispassionately, and the other factors carry greater weight.
When you say the material considerations relied on by the appellant, most particularly the fallback position, just remind me what other considerations were.
Well, so there are the materials themselves. There are sustainability issues, aren't there, about reuse of buildings? That there are other things that you might take into account, but principally it's the fallback position of moving within the curtilage. Thank you. So what we say is, look, ground A, deemed permission, very special circumstances do exist. Ground F then, assuming ground A fails, appellant submits requirement to demolish the buildings is sufficient to remedy the breach. So as discussed during the session yesterday, council has been overzealous in some regards, taken an unorthodox stance in others. So the notice only needs to refer to building, and it was helpful clarification that it wasn't intended to catch the existing hard standing on which the vehicles do and will park. So when I say unorthodox, that point relates to, you know, hard standing underneath the building. I've never seen that before, but it's been clarified, doesn't matter. Providing the notice is modified to extend to the building only, then that will suffice. I don't accept that is just clarification. It is a change. And I think that the point that you were discussing with Mr. Leathhead, it feels to me that that is a reduction. It's not just a clarification. The notice on its face is overstating requirements. And I think on the basis that of the discussion yesterday, the council is wrong on that. I know why Mr. Leathhead said that, because of his cost claim, but actually it seems to me that the appeal on ground F should succeed. Ground G, having taken instructions from the appellant, it became apparent what a specialist job deconstruction, movement, and storage of the infant building would be. Specialist contractor, hard to program in current circumstances, given the paucity of skilled labour. Council indicated it wasn't overly concerned about timescale as long as it wasn't too long. What we say is, look, 6 months, preferably 9, no legitimate purpose in forcing the appellant to rush a technical job over the winter months. That's a matter for you. Concluding remarks then, based on the evidence it's called, the appellant respectfully requests ground A should succeed, ground F dealt with above, failing all that, ground G should succeed. I think it's just overall, look, I understand people get excited and councils get excited about things, but other than fluffing up the feathers of the council, making neat legal points and all of that, get all of that. In planning terms, it makes absolutely no sense to rip down high quality buildings made of top quality materials just to see them moved a few meters away and made a couple of meters lower to ridge. And what we say is, look, that's a colossal waste of time, money, and materials to do so. And it's something antithetical to sound planning and the public interest. So I'm not saying either that's a license for people just to do what they want, but here, the technical breaches that there are in relation to Class E mean that, yeah, it's outside, they're outside permitted development rights, but you are going to get the exercise of PD rights. You are going to get Class E buildings. This house does need a garage, and you know there is good reason for another ancillary building. In determining ground A, you've got to stand back with respect and say, is this actually what we should be doing, given the very limited degree of harm that there is? And just dispassionately looking at this, what a waste of time that would be. So for those reasons, we say that the very special circumstances exist, and therefore ground A should be granted, or the deemed planning permission to ground A should be granted for both of those buildings. So unless I can further assist, those are my closing submissions on the substance of the planning case.
No. Thank you very much. You're happy, that you don't need to say anything else, obviously, as I say, Mr. Hardy will get the last word, but I think I've got your cases fairly clear.
Thank you. So there was one point where there were a couple of ad hominem remarks. There was a point in relation to ground F where it was perhaps being suggested that I wasn't being completely straightforward. I was, sir, and I act on instructions. But perhaps I misunderstood what my learned friend said.
Right, okay. Thank you very much indeed. So 20 to 1. Have you got your final costs?
Yes, sir. I have. It was emailed last night. I appreciate my learned friend for whatever reason didn't get it. What I wonder, and bear in mind we are on a public inquiry, is if it's worth me making the application and then perhaps adjourning and giving my learned friend time to think about it and make whatever amendments he wishes to make.
Just to hear, I've not read the email,
Yeah.
so actually just to hear it
I think
read
that's right, yeah.
would be good, and then I'll form with you. Yeah.
Yeah, and that will take us to a convenient point
For lunch.
Well,
Yeah.
yes, although if I can deal with it, because I have made some amendments to this, and I'll be pragmatic about it. I can deal with it. Do it before lunch, I'm happy.
Yes, because if I can avoid a long lunch adjournment, I will.
Oh, of course.
Yes, I agree, yeah.
It was merely
I'll be
to
sensible about it.
Yeah.
fair to
Sure.
my learned friend. So I'll hand it round.
Thank you very much.
Thank you. So for the benefit of those listening, this is an updated application. In fact, I should probably put that in the tram lines at the top. Not everyone watching may be aware that you so requested that an application for costs was submitted on the 1st of November. Various things have
Just
changed.
to clarify, I knew there was going to be an application for costs, and I didn't request an application for costs.
No, so you did request it, but by the Thanks, sir. The request was that any application for costs
Yes.
or that the intended application costs be submitted by the 1st of November. This is an updated application to reflect changes since then. It has only been, as you'll see, slightly modified. So this is an application by the council for a partial but significant award of costs against the appellant, Mr. Robert Hadfield. The appellant appealed against the council's decision to issue against 2 enforcement notices, and I've described them there. Turning over the page, this application is made having regard to the planning practice guidance on appeals. No, unless to the public you think it's
No, I mean, I think we can summarise it for the public that awards of costs can be made where there has been unreasonable behaviour, which also results in wasted costs. And then it gives examples of a non-exhaustive list of examples of what that might be. But that's the basic. That's the nub of it.
Thank you, sir. And then I've said I'll read from paragraph 7. The application arises from the unreasonable conduct of the appellant, both on procedural and substantive grounds. The council is applying for an award of costs in respect to the work undertaken to date in relation to the appeal by officers and counsel in advising, preparing for the inquiry and drafting and reviewing appeal documentation and evidence, as well as for other administrative costs in relation to the aborted inquiry that sat on 6th September 2022. These administrative costs include the need to unnecessarily book meeting rooms, arrange refreshments, set up and provide web streaming using equipment that might have been needed elsewhere, send notifications to interested parties, and liaise and arrange to accommodate other interested parties. This paragraph is new and it responds to a point made in Learned Friend's initial response. Seen yesterday, the bookings refreshments had already been organised well before it was agreed to hold the inquiry virtually. Further, and for the avoidance of doubt, the council is applying for the late withdrawal of Appeal A and Appeal B Ground C, and the substantive weakness in the appellant's case in relation to Appeal A and Ground B. grounds A and C. So it isn't restricted to a date referred to by my learned friend, so 6th of September 2022. In fact, ground C was in the early application and it was withdrawn after that date. I've then set out the chronology, so I'm not sure how helpful it would necessarily be to read that. The only addition to the chronology since the last application is yesterday. The inquiry resumes. The appellant withdrew a PLA. I put just for 10 a.m. I was literally 9:59, as you remember. So we were asked to leave the room. And then the application itself, the appellant's unreasonable behaviour justifying a procedural award of costs. The appellant's lack of engagement for 6th of September 2022. The appellants failed to engage with the inquiry for several months before it was scheduled to sit on the 6th of September 2022. Despite being contacted on numerous occasions by the council to agree matters such as inquiry timetable, statement of common ground, and submit a proof of evidence, no response was received. There was then still no engagement by the appellant after PINs confirmed to the parties on the 8th of August 2022. After the council expressed its concerns about the appellant's lack of engagement, it was not until 31st of August 2022 that the appellant sought an adjournment of the inquiry as a consequence of his personal reasons, which request was denied by the inspector. Just noting in passing, I don't think we've seen the appellant at all, not even at the site visit today. While the council is sympathetic to the personal circumstances of the appellant's agent, this lack of engagement was unreasonable for the following reasons. The inquiry date was set by PINs on the 21st of March 2022, some 5 months in advance, and the appellant had ample opportunity to inform the council and PINs of any difficulties he was having in preparing for the inquiry. The adjournment request on 31st of August was only 3 working days before the scheduled inquiry on the 6th of September 2022. On the 6th of September 2022, the appellant still had not produced a proof of evidence and only submitted a draft version of the statement of common ground to the council the day before, which is too late for the council to be able to agree a final version and send it to PINs. When the inquiry sat on the 6th of September 2022, the appellant failed to attend. It's not clear if he was upset then or if there's some other reason. And no witnesses attended either. While the appellant's agent was present, he confirmed that he would not be giving evidence. There was no reasonable chance the inquiry could have proceeded without the appellant or any witnesses supporting his case attending. This behaviour falls squarely within the sort of unreasonable behaviour described by the PPG at paragraph 52 as justifying an award of costs against an appellant on procedural grounds. It is plainly unreasonable. Indeed, the appellant's agent, as you will recall, sir, appeared to accept this when the inquiry sat on the 6th of September 2022. And then the appellant's late withdrawal of PLA. The weaknesses in the appellant's case in relation to ground A, which relied solely on ground D, statutory ground D, has been commented on frequently by the council, including in the version of the COS application that was submitted on the 1st of November 2022. Those weaknesses are set out again in this application below. The reason given by the appellant for withdrawing this was because the most recent document, the daughter of the appellant's partner, has moved out. And I think that's what we were told yesterday. I think today we're being told she's moving out imminently. This is not a good reason for withdrawing the appeal. If Brinwood Lodge had been in independent residential use for many years, as the appellant attempted to argue, another tenant could have been found. And I'll expand on that. If it's still in residential use today, there is no rational reason for withdrawing that appeal. The fact that the appellant's girlfriend's daughter is thinking about moving out has no bearing on that at all. Indeed, the use of the property by an occupier closely connected to appellants adds weight to the council's suggestion that the building was in fact in ancillary use. The appellant's late withdrawal of appeal B, ground C. The appellant initially relied on ground C. He argued that the unauthorised buildings, the new garage and the unfinished building did not constitute breach of planning control as they benefited from permitted development rights under Class E. This was said to be because they came within the curtilage of the lodge. On the 4th of October 2022, the appellant informed the council he was no longer relying on this ground. No substantive reasons were provided. This ground formed a main component of the appeal and did not have any reasonable prospects of success. The unauthorised buildings were very obviously not within the curtilage of the lodge. On no reasonable analysis could the unauthorised buildings be considered to be incidental to the lodge, and the appellant did not attempt to explain how this could be so. The unauthorised buildings are excluded from the permitted development rights conferred on ground C as a result of the limitations within paragraph E1. Indeed, the appellant's own legal advice submitted with his statement of case on curtilage did not support his own ground C appeal, since he referred to Brinwood House and not Brinwood Lodge. As a result of this confusion, the council was obliged to invest further time and resources considering whether the buildings could be said to benefit from permitted development rights under Class E if Brinwood House was considered instead. However, even if Brinwood House was considered rather than Brinwood Lodge, as the appellant put his case, the ground could still not have succeeded. The councillors argue that the buildings do not come within the curtilage of Brinwood House. However, even if the council were to form the view that there was at least a case that they were, the unauthorised buildings could not be considered to be reasonably incidental to Brinwood House and were excluded as well as limitations within paragraph E1, as explained in Mr. Hawley's evidence. Thus, the ground was always misconceived, even if every effort were made to consider that the appellant did not even try to advance. It will be argued below. It would be argued that this should give rise to substantive award of costs for this reason. It is argued that this should give rise to substantive award of costs. However, even if you so were to decide that there was a time when it was reasonable for the appellant to rely on the ground, that the appellant should have realised much sooner that it stood no reasonable prospect of success and spared the council the need to invest in time and resources in responding to it, that there was no material change in circumstances. And then I turn to the appellant's unreasonable behaviour justifying a substantive award of costs. The appeals submitted by the appellant are unusually weak. The PPG is clear at paragraph 53 that an appellant is at risk of an award of costs being made against him if the appeal or ground appeal had no reasonable prospects of succeeding. So the reference to a lack of merit refers back to the PPG. Almost all of the grounds of appeal submitted have no reasonable prospect of succeeding. PLA ground D, when the council considered the appellant's LDC application 2021, which is before you, sir, the lack of credible physical and documentary evidence to support the alleged residential use of the lodge for the relevant period was discussed in the officer's report. Despite this and the refusal of the application, the appellant has failed to produce further evidence for this appeal. Indeed, even though the lack of evidence was again discussed when the inquiry sat on the 6th of September 2022, no further evidence was provided, even when there was an opportunity, even when further evidence generally in relation to appeals submitted, no further evidence on ground D was put in. The ground has no reasonable prospect of success and has resulted in cost the council in defending the appeal. And of course, it was withdrawn at a minute to midnight, as it were. Appeal B ground C, as set out above, the appellant has indicated he no longer relies on his ground C appeal under appeal B. But the reasons already stated, this ground never had any reasonable prospects of success and justifies the substantive award of cost of time, resources the council expended in dealing with it. Appeal B ground A, the appellant's appeal under ground A furthers no reasonable prospects of success. The unauthorised buildings enforced against under in B in the green belt will only be acceptable if they're not inappropriate development or be in very special circumstances apply. They are plainly inappropriate development, that's agreed. And there's been no serious attempt to argue very special circumstances. Further, the appellant has acted unreasonably in that he's failed to have regard either to the NPPF or greenbelt policies in the development plan. The unauthorised buildings, this is in their evidence, the unauthorised buildings are plainly inappropriate development in the greenbelt, and that carries significant volume of footprint of development on the site. One of the buildings is unfinished, and we say it's quite clearly unfinished, and what was not completed at the time of the notice cannot be completed by a ground A appeal of Arnold. There's no misconception there. The appellant has sought to downplay its spatial impact by introducing fallback arguments which cannot lawfully be carried out, as the buildings do not meet the requirements of permitted development, and that appears to be now accepted. The appellant has not addressed or assessed the visual impact upon openness. His statements do not cover winter views and are limited with regard to information on the visibility of views within the special landscape area. On any reasonable objective analysis, when taking spatial and visual factors together, the appellant should have seen that it could only be concluded that the impact upon the openness of the green belt would be negative. He therefore should have been aware that any harm to the openness of the green belt would be a consideration to which substantial weight would be afforded. The appellant's arguments about vehicle parking are weak and could not possibly amount to very special circumstances sufficient by themselves or cumulatively to outweigh clearly the green belt and other harm to the green belt and other harm. The unreasonableness of the appellant in advancing the ground further justifies a substantive award of costs. For the reasons above, the appellant's conduct in these appeals has been unreasonable in numerous respects and justifies a partial but significant award of costs on both procedural and substantive grounds. So I dealt also briefly yesterday, just to respond to a point made. There was an issue about whether the council has refused to engage with the appellant. The council has engaged with the appellant over many years and on many occasions. There was one particular email, which I think is before you, where the appellant made quite specific requests. The email's not before me. I think one of them was that the council just dropped its ground A appeal. Clearly,
Sorry, the council has.
I think that's right. Forgive me if I get the email up. I'll not be.
Is this with
Yeah, I think
what
it's
was submitted to do in the inquiry document 10?
Yeah. So a specific deal was suggested to the council. So, you know, the council was asked to concede on a new garage, concede to accept that it wasn't inappropriate development, i.e. was appropriate development in the Greenbelt, and that, well, that doesn't even make sense without special circumstances. This was just before the appeal. What was being asked of the council, there was no prospect of the council agreeing to these points, and it was perfectly reasonable for the council to indicate that there was no point in discussing those matters further. The council is under no obligation whatsoever to do so, and has engaged with the appellant on many occasions over several years. So unless I can assist you further, that is the cost application on behalf of the council.
No, I said I was, you know, I would avoid a long lunch break if I can, because like most condemned men, I ate a very big breakfast this morning, anticipating this eventuality. But if anybody does need a break, just let you know. But how long would you need to respond?
No, I don't think I do, actually. I mean, there's a couple of extemporary points I can make, but I think that what I have written is going to be a good basis. So there's 2 points. One is the things that you said about the inquiry on the 6th of September, the difference between postponement and adjournment. I need to just doctor it for that purpose. And then there's a couple of points in response, but I'm happy to go on.
Right, but I will just adjourn just briefly, the comfort break, call it till 1:05. Okay.
Thank you. additional closing submissions. And in due course, your cost application, if you have it, your cost response, if it is in writing.
Yes. Something, so I would allow you to give them to you.
Yeah, sure. It's not 5 past yet anyway, so. By the way, I have now received the email with your updated costs. Thank you very much. And just before you start, Mr. Hardy, may I also ask that that as far as your written closings are concerned and I've already got Mr. Hardy's Mr. Leithhead's updated cost application, but if you could email the closings and the response to the case officer as well. The reason for that is now that we've got electronic files, unless they're emailed in, they will never appear on.
I mean, Mr. Tubb has been dealing with that. Do you know who the case? I don't even know who the
Craig
case.
Maxwell, but if you address it to what was it, Ian? Team E2, then even if he's not there,
I'll just put the reference
somebody
on it.
else.
Yeah,
will
that's
do it.
fine. Can I also say that yesterday I promised to give you copies of the legal authorities. So there was Tonbridge, there was Sam Smith's Oxton Farms. There was also, I referred to Red Hill Aerodrome as well. So if you're happy with that, and I copy that to the council, then you've just got them. I'm sure you've got them already.
Well, I can get them, but I don't.
Well, in which case, if I am relying on those, and I think you ought to have a copy of those. So if the council is agreeable to that, I'll copy them in when I send them to you.
Yeah, I mean, we're not saying anything more about them than has already been said, so that's fine.
Exactly.
But when you send those in, if you say as requested by the inspector, otherwise they'll just send it back as late.
I'll put them all in one email.
Yeah.
So that all the documents go in as requested at the inquiry, and then you got them.
Okay, that's great. Thank you.
Good. Well, by way of overview, it seems to me to be an odd costs application in a number of respects, and also one where I think the general attitude of the council that was again betrayed by those off-piece comments at the end about the meeting. I mean, there is an ongoing obligation on the part of an authority to try and narrow issues and to act in the public interest. And what my own friend has done is misread that email, because there is a telephone conversation, which you will see. There was telephone discussions between Mr. Telford and Mr. Purcell, at which a whole range of things were discussed. And what came out of that was one proposal that was up for discussion. But it wasn't the only thing. It wasn't take this or leave it. It was there for discussion. And what the council did was shut up shop and say we're not prepared to meet. That's the criticism. So what the council is trying to do there is characterise that as a single shot. It absolutely wasn't. And of course, yesterday, when the positions moved substantially, yesterday we were told there was no refusal by the council to meet at all. That now has fallen away. I think now the evidence is before you. But by way of response, let's go to my text and we'll pick up some other points. There's we know it's a response, an updated position in writing was expected from the council on the evening of 1st of December. I didn't receive it. I'm not saying it wasn't, but I didn't get it until this morning. I received it from Mr. Leithhead. Any amendment will be considered subsequently. Well, I'm saying I don't need that other than extemporary remarks. It's distinctly unattractive application for costs, which doesn't sit well with the council's responsibility to act fairly proportionally in the public interest. I go further. I think it casts the council in a very poor light. Personal tragedy in this case, breast cancer, is not something which should be used as a springboard for a claim for costs in a planning appeal. And certainly if I was advising the council, we wouldn't be making this sort of application. The factual circumstances in this case may be unusual, but they're well known to the council. Significantly, no submissions are made against the appellant himself, or submissions concern the appellant's agent, Mr. Telford. In the circumstances of this case, the appellant hasn't acted unreasonably procedurally or substantively, such that the partial award of costs sought by the council should be granted. So factual material largely agreed, including the chronology of events, largely agreed. There's some commentary in the chronology. I don't accept that, but it's not, don't need to take too much time up with that. Paragraphs in the PPG which you quoted are well known and don't need to be repeated. It is just worth a reference to paragraph 49 when you come to look at it about, it's obviously not an exhaustive list, but where a council refuses to enter into pre-application discussions or provide information when a more helpful approach would have resulted in either appeal being avoided together or issues being narrowed, then that would reduce the expense associated with the appeal. Well, that absolutely fits in with the point I've made about trying to narrow issues and the council saying no. As currently articulated, the claim from the council is poorly articulated and unclear. So paragraph 8, and this was on the basis of what I had last night rather than today, and it picks up on a discussion actually that you and I had yesterday, sir, which it was that paragraph 8 was in the section headed the application in outline and expressly stated that any cost claim was only relating to aborted costs referable to the aborted inquiry that opened on the 6th of September 2022. Paragraph 8 came immediately after paragraph 7, which stated that the application arises from the unreasonable conduct of the appellant, both in procedural and substantive grounds. So a fair reading of that was paragraph 8 was circumscribing what had been set out in paragraph 7. Now you yesterday said, well, look, you've got to read this as a whole, encourage the appellant to look at paragraph 22 as was, but that's not inconsistent in the way that the matter being interpreted. The council hasn't been clear. Now, that's been clarified this morning, that's fine. But as I say, I wrote this last night and it seemed to me that the way Mr. Leithhead had set this out just wasn't clear, and that paragraph 8 following paragraph 7 was circumscribing what the claim is about. Whilst quantum isn't a matter for discussion at this stage, and again, there has been an amendment to or a clarification this morning, but it's submitted that costs associated with booking meeting rooms and arranging refreshments were not needed for what could have been a fully virtual event. There are no costs associated with using equipment that might have been needed elsewhere. I noticed that bit's been dropped from the version this morning, unless evidence is provided that otherwise unnecessary higher costs were incurred, of which there is none. I have to say, it's very scratching around. If we're talking about some tea and coffee, and well, that would be it, because I haven't seen anything else that's made available.
It's good coffee, though.
It's very good. It's very good coffee, but I mean, if that is an unusual item to include in a cost claim for a council, there we go. Notifications and procedures are part of the statutory responsibilities of a local planning authority. People get paid. It's what they do. It's the job. And this paragraph alone demonstrates the heavy-handed nature of the application. It's a healthy degree of overwriting on the part of Mr. Leithhead, which is something that's characterised both sets of submissions. The appellant did the responsible thing to instruct Mr. Telford as his professional agent, Mr. Telford's wife, And I've asked him, he doesn't mind me disclosing, he's diagnosed with breast cancer January 2022, very seriously ill, very quickly. Mr. Telford became a full-time carer and forced to put work matters in abeyance. I think it is difficult to comprehend the emotional and physical strain that he was under. You will have appreciated Mr. Telford is in the twilight years of his career, if I can put it like that. Somebody who is, an emotional, sentient person. He was rocked by what's happened. He puts his hands up and he says, "Yeah, I couldn't really cope."
May I just make one comment about this? And
Yes.
that is that when I do the cost decision and or report, I will make very, very limited reference to those circumstances. That does not mean that I haven't fully appreciated their depth and significance. But for example, you said to me, Mr. Telford doesn't mind this being disclosed, but it's information about his wife, and I don't have, with the GPDR, it's very difficult nowadays. I don't have.
Yeah, I think that's
her-
understood.
her-
It
her
can be
consent.
personal circuit. Yeah.
So I'm just flagging that up,
Yeah.
that I'll refer in very general terms to those things, but not in any great
Yes.
detail.
It's important, absolutely right. Of course, it's important to know what that is, because some people could say, well, there
Yeah.
was a bit of illness in the family, whatever, you don't know. But this is something that goes right to the heart of life, and it's that big a thing. So, lack of engagement. Whilst the lack of engagement alleged in paragraphs 1 and 2 of the application on the part of Mr. Telford is factually correct, and I should say, of course, these paragraph references are to the as was claim. It's perfectly understandable given the personal turmoil that was going through. It may be a matter of regret that he didn't seek to pass his workload on to another planning professional. He can and should be forgiven for not thinking more clearly. Paragraph 1A, it was telling the council records that no response was received. The allegation is not that Mr. Telford was evasive or unhelpful, which he has never been. You can form a view. Mr. Telford, exceedingly nice chap, but circumstances were simply too much for him to cope with. Papers were put in a drawer, emails were not read, no work was undertaken on this file or any other file as a result of those caring responsibilities. So by late August, Mrs. Telford's position had improved to some extent. She's still very seriously ill, that's why he's not here today. She's in hospital. This was the point on, it came a point on 31st of August that Mr. Telford sought should be postponed rather than adjournment. I think that's your point. I think it was. I think it was seeking a postponement. I haven't gone back to check the emails, but you'll know whether it was a postponement.
Yeah,
or an
well,
adjournment.
my basic point is that you open and adjourn hearings and inquiries. I hadn't ever opened at this stage of the inquiry, so it is postponement of the commencement of it rather than adjournment of the proceeding.
I absolutely understand that difference. What I mean is, I'm not sure whether in his own language, Mr. Telford applied for an adjournment or postponement.
Yeah,
I
well,
don't
I
know.
think I think he may have expressed it in terms of adjournment. Obviously, once we got to the 6th of September, then that's what it was. But
Yeah, that's what I was meaning. Obviously, I know the difference, but I wasn't sure what he had physically applied for because I haven't gone back to check the emails.
Okay.
Right. So the obvious and decent thing to do is for the council to accept tragic circumstances, agree to make a joint application for a postponement. It should be of the inquiry to pins. New procedural timetable could have been set out. The council didn't take that opportunity, and the council itself decided to incur expenditure when it did not need to do so. And that was a choice for it, and such expenditure shouldn't be laid at the door of the appellant. And it might be late, but I've had experience recently of it was 2 days to go. Council said, yeah, absolutely, and there was I've had it both ways round. So it was an opportunity that the council didn't take. Rather than agree to a postponement, it was the decision of pins to open the inquiry on the 6th of September, just so that Mr. Telford could make then a further application, or could make an application for an adjournment, whichever it is. Procedure, of course, a matter for you, sir. Mr. Telford had no choice to appear and make his request. However, respectfully, that inquiry session, we say, could have been avoided. Now, Mr. Telford communicated that he wasn't in a position to proceed on 6th of September. It should have come as no surprise to the council that no witnesses were in attendance. The inquiry was never going to be effective on that basis, and the council was aware of that fact. As I understand it, council came here to the offices, didn't need to do that, could have been dealt with virtually, wouldn't have been it would have been an hour of his time rather than a day. The behaviour of the appellant is not plainly unreasonable as set out in paragraph 3 or at all. Personal circumstances before Mr. Talbot were devastating. Whilst the council may have been irritated in a heavy-handed way, it doesn't mean that the qualifying criteria for an award of costs on procedural grounds are met. And cutting to the chase, what you are doing is fixing the appellant who has appointed a planning agent with costs by reason of a veteran planning consultant who lost his head because his wife's got breast cancer. That's what this cost application boils down to. And I say that is it doesn't sit well with the public duty of a local authority to bring this cost application, and B, it's not unreasonable. Appellant's late withdrawal then of appeal B, ground C. Element of the claim is without merit. Mr. Telford was well enough to start working again properly. He was able to consider the statement of case from the council and third-party representations. Having reached the view that ground C and appeal B wasn't likely to succeed in light of the reasons set out by opposing parties, it was a responsible and reasonable thing to do to withdraw it at the earliest opportunity, which he did, and that's precisely what a responsible party to an inquiry required to do. Now, I think there's a distinction to be drawn between qualitative arguments about curtilage and metrics. And you've seen in the papers that there's a debate or there's a discussion about where you measure height from. So the volumetric stuff. And what the council did was, provide information. I think there's reference to the case in Burden about where you measure buildings from. So it's not that this was hopeless from the start, but Mr. Telford said, okay, well, we've seen the case from the other side. And in metrical terms, we're absolutely not giving up the curtilage point. We stick by it right now, absolutely do. But the metric point would have been a difficulty facing that Class E argument anyway. So what he did was look at that and go, okay, well, on the basis of burden metrics, the metrics are such that, this isn't going to succeed. So he does the responsible thing. That's exactly what the inquiry procedure rules ask you to do. Look at the other side, review your position, and take a view. That's what he did. So just because the council doesn't agree with the ground of appeal doesn't make it unreasonable for an appellant to pursue it. So that point about curtilage is absolutely arguable, but it doesn't matter because it's got to be curtilage and all the metrics. If you're not going to comply with the metrics, well, you're not going to succeed on Class E. So that was the reason for the withdrawal. Again, whilst quantum isn't for determination, paragraphs 8 to 10 are noteworthy. The reasons why the council state the buildings were excluded as a result of physical limitations within E1 apply just the same, whether it was Brinwood House or Brinwood Lodge that was being considered. So, it's a mystery to me in the way the applications put the costs about, it was all confusion and David Manley's advice and so on. It doesn't matter because whether it was in arguments about curtilage of Brinwood House or Brinwood Lodge, the council was saying you never qualified anyway because of the metrics. So no additional work of any sort was required in that regard. It's a good indication of heavy-handedness and overwriting. So given the personal circumstances of Mr. Telford, it's not the case that withdrawal of ground C should have been communicated sooner. What was done was reasonable and in plenty of time for the inquiry 1st of December. And actually that is what we're exhorted to do, to look at the other side's case and take a realistic view. That shouldn't result in a cost award against the appellant person. So unreasonable behaviour then justifying a substantive award. It's really odd, got to say. There's no basis for a cost claim for the council to submit the appeals are unusually weak. The recipient of an enforcement notice has got every right to defend his or her position and see that tested before an inspector. That is subject to examples of unreasonableness. But in substantive terms, having a case that the council think is weak isn't, not in the 27 years I've been doing this job, unreasonable behaviour. The sanction of costs is there in respect to behaviour which is judged to be unreasonable, not to judge a stance which the council may not agree with.
Well, in the end, it just comes down to whether I consider that the arguments had no reasonable prospect of success. That's what it comes down to in the end, isn't it?
Well, I think it's got to be, I think it's got to be a bit more than that, really.
I
It's
thought
got
that's
to be no, I mean, I don't know whether, unusually weak isn't a test. That would be a saying, look, that's the council's stance. I think you'd have to say they're almost unarguable. I think reasonable prospects, that indicates to me a 50-50 chance.
No, I mean, no reasonable prospect of success.
I think that depends on how you determine. To me, reasonable prospects. What I'm saying is that the test absolutely isn't, and I would put it close to being an argument. If it's absolutely, if you are running up against a brick wall, and I think that what's helpful in that regard is when you go to the PPG in relation to examples of substantive unreasonableness. Say you had got a fresh High Court decision, which is squarely on all fours with your case, and you in the teeth of that carried on. I think that absolutely that's unreasonable. But I think just having having factors which absolutely when you apply that's enough. But it certainly isn't a test of unusually weak. That's just characterization by the council. It's just
Right. I mean, so just to get the wording right, this is the bit from the PPG, and
yes,
I hate the length of references for the PPG,
yes,
but it's paragraph 53 in the appeals section.
I'm just looking at that now. So let me turn that up if I may. 53. 51, 52. 53, yeah.
Yeah, so the right of appeals to be exercised in a reasonable manner. Appellant is at risk of an award of costs being made against them if the appeal or ground of appeal had no reasonable prospect of succeeding, and it gives examples of when that may occur. But that's the test, really, isn't it?
That's the wording, yeah. But how you interpret that, I don't think that is a sort of 50-50. To me, that means goodness, if we were as lawyers, say commercially, if you've got a 20% prospect of success, that's a reasonable thing to do to put that, particularly with enforcement. So
I'm not going to put a percentage figure on it, but
no. But what I'm
Yeah.
trying to do there is just give a flavour. You get the point that
Yeah.
actually I think it's close to unarguable. It's perverse to take this sort of point, and therefore that would be an unreasonable thing to do. It will be up to you, but I don't want to be quoted as saying, look, that's the absolute test I'm setting. One of
but the expression close to unarguable, I think, fits with my
close to an argument.
Yeah.
And here we absolutely do not fall foul of that testing. So back to my text. Appeal a ground D. I mean, the elements of the claim point, so hopeless, the council element of the council claim, so because the appellant relied on a statutory declaration. It's got a special status in terms of evidence, which the council persistently ignored. The appellant was entitled to submit the evidence was sufficient to discharge the burden of proof. The status which under the Act what that they hold. So it wasn't unreasonable to hold that view. Many a case has been won on a single start day. The decision of the appellant to withdraw ground D at this inquiry session is because the occupant premise is now likely to move out. Decision to withdraw as a separate matter for obvious reason is not commented on by the council, although it now has been in the updated. There should be no award of costs because the second qualifying criteria that there's been no abortive expenditure isn't met. I think it's right in saying the appellant wanted the appeals determined by way of written representations. That was the original procedural choice, and it was the council's decision to challenge the veracity of a statutory declaration that led to the proceedings being uprated and then to an inquiry, which then subsisted for appeal B as well. So once appeal A had been elevated to an inquiry, then appeal B was taken with that. The council was bound to attend with counsel and witnesses for the round table session on appeal B, which was always going to be part of an inquiry format, and which you yesterday, sir, chose to maintain as an inquiry, even though it was the only event.
But even if it had been dealt with on written representations, there still would have been work involved in addressing ground D, which was ultimately withdrawn. I'm unlikely to conclude that it was unreasonable of the council to say they wanted an inquiry, because I decided an inquiry was appropriate. And it usually is where there's factual matters in dispute on a ground D or LDC case. Other inspectors may take a different view, but that's generally been the stance of the planning inspector. It's certainly my stance.
Yeah, so what they've got to do is got to show abortive expenditure. So the council continue to argue, or have continued to argue, about the extent of curtilage. It's been a point that they persisted with under ground A in appeal B. So as you know, they are arguing, because it was put to you yesterday, about where the curtilage is. So in relation to the fallback position, they're saying it's outside the curtilage, and I've asked you.
Yeah, but we're talking about the withdrawal of ground D here.
Yes, but we're talking about abortive expenditure. They've got to demonstrate not just that there is a timing point, but it's led to abortive.
But as I said, even if it had been dealt with by written representations, they would have incurred costs.
But the point is, you have to show.
It might be my fault, Mr. Hardy, but as I say,
No, well, you need to understand it, because
Yeah,
I've
sure.
not been clear. Yeah. So there's two parts, obviously. There's this. Yeah, I mean, let's just take a breath. It'd be very easy just to say, "Oh goodness me, there's been withdrawal of a ground of appeal, therefore costs, of course, that follows." Yeah, you've got to look at it more, in a more thorough way than that. And what you've got to show is that all the qualifying criteria met. You've got to show, yes, that there's behaviour which might lead to, which might trigger that, but also abortive expenditure. So what is the work that's been done in relation to the in relation to the ground D? The bulk of that is to do with curtilage, because the argument was you're outside Class C because you are not within the curtilage. That's their case.
but the ground, the appeal A had consequences for appeal B because of the ground C and curtilage argument, but appeal A was about whether the change of use of that building to a dwelling was lawful or not. Curtilage didn't come into that.
Well, it did, didn't it? If you look at the evidence.
No, the question was whether it had been used as a separate dwelling for 4 years.
Well, you'll have to form your view on that. But if you go back,
Well, I have formed a view on that, unless you can tell me why it's wrong. That's what I'm trying to do.
well, you just need to. If you look at the paper, if you look at the papers.
No,
that's fine.
but you're saying you've got to establish unreasonableness, and in this case, leave aside the arguments about whether there was any basis for the ground D appeal.
Yep.
The fact is, it's been withdrawn. So
Yep.
primarily, the question on unreasonableness is whether there was a good reason for withdrawal.
Mhm.
And I've heard what both of you have said about that.
Yep.
Beyond that, there is a question of whether costs were wasted. And unless you're saying there was no work or no significant work involved in responding to appeal A in whatever form it was, there must have been some wasted expense. Not for me to determine how much it was, but if you're saying they did nothing in relation,
I'm saying
to
it's
appeal,
de minimis. I say that they cannot demonstrate that's abortive work. So I can't take it any further than that. I'll be happy for you. I mean, even if they get costs, I'll be very interested to see the bill of lading, because it's not going to be very much.
fortunately, I don't have to.
No, you don't have to worry. You don't have to worry about that, but obviously we will scour over them. Right, okay, council argued the closing submission of writing secretary.
Sorry, I've lost track of what
We're at 219,
Yeah,
weren't we?
Yep, sorry. Got it.
Council argued for closing submissions of writing secretary December, when it could have avoided attendance on the 2nd. I think that goes to the point about today's costs from today, in the end, you ask the parties to come back after the site visit. In short, properly analysed, as it's turned out, withdrawal of appeal, even though it was on the first day of the inquiry, hasn't resulted in abortive expenditure. So that's our view, our submission. You have to inform a view. Appeal B, then ground A. Substantively, then, I mean, we've dealt with much of this. Quite, spent a full day discussing ground A, highly credible. Council may now feel rather silly. It's highly unusual for council to make an application. I don't really need to read this because the point is, if it goes to the questionnaire, is it close to being unarguable? Absolutely not. We've got you may succeed. So, whilst the council may disagree with the case, the appellant puts no basis whatever for an application costs. Council has had its chance to make submissions on the merits. Clearly misunderstood the fallback arguments. Completely ignored the point that buildings which do comply with the metrical requirements in Class C can and would be cited elsewhere in the curtilage, and so in doing that, they've ignored judicial authority in Mansell and Tonbridge. It's not helpful to instruct the council to set out basic principles of development management of the Greenbelt. In paragraphs 20F and 20G, we're well aware of Greenbelt policy in the law, arguing a case that the council doesn't agree with isn't unreasonable. Conclusions then, so for the reasons set out above, application is unattractive in conception and in articulation. And it's a mark of a council that's become overexcited that it seeks to castigate the case of an appellant before it's even heard as being unreasonable to a point that costs award should be made. It's had its chance to make its arguments on ground and appeal B can do so in the normal way. Lack of judgment is palpable. Costs fall where they lie, of course, including enforcement appeals. Nothing here. There's nothing in here. What has happened here to dislodge that normal rule? So, as a result, the application of the costs, as set out by the council, both in its initial statement and in its revised statement, it should fail in its entirety. So, for all those reasons, the applications, whether they are partial, procedural, substantial, are resisted. So, unless I can further assist, thank you.
Thank you, Mr. Hardy. Now, with costs, obviously the applicant gets the last word. Is there anything else you need to say, Mr. Lee?
Thank you. So very briefly, just a couple of points in response. I'm not sure where it gets Mr. Hardy anyway. He's not making an application for cost, but this business about this refusal to have a meeting with the appellant. Mr. Hardy mentioned just now that the council had been talking on the phone with the appellant, which was the precursor to the email, and then decided that following those discussions and following the email, the meeting wasn't going to get anyone further. That is entirely reasonable. The council, as I said, had engaged with the appellant on many occasions over several years. It isn't required to meet with the appellant on any given opportunity. If it's close to inquiry, there really is no point in doing so. It wasn't the case that they're refusing to engage with him, full stop. There's a factual error in this, which is no criticism of my learned friend. He wasn't involved at this stage. He says in his, just check I get the right version, he criticises with two factual errors. He says that Mr. Telford just
So which paragraph?
well, there's a general point about Mr. Telford, and so you'll remember from last time just how carefully the council dealt with this matter in both its correspondence to PINS and at the last hearing. Mr. Telford is in a very difficult circumstance. The difficulty that the council had two main difficulties in this. The first is that there was just no engagement at all with the appellant. Proofs weren't being produced, statement of common ground, nothing was coming forward. But Mr. Hardy doesn't seem to be aware of this. Mr. Telford was engaging with the council regularly and repeatedly on other matters. So the council knew that Mr. Telford was able to deal with work, just for whatever reason, the appellant wasn't engaging on this particular case. As to the chronology, there's a specific point in the 2.8, and again, I'm not sure where it gets Mr. Hardy, but he says the council didn't take the opportunity to agree a postponement. This is no criticism of Mr. Hardy, but so if you go back to the chronology, which and again I didn't read this out, so he may well have missed it, but it's on page 6 of the updated application. The deadline for proofs was the 9th of August. No proof was submitted. Then the council wrote to him again on the 25th of August. I believe Pins was copied into that, but the emails before you are AB6. And then a week or so later, the appellant's agent wrote to Pins to request a postponement of the inquiry. And for what it's worth, that word is used there, according to the agent. This is private matter, which has been going on since April 2022. And then, so the appellant wrote to Pins requesting the postponement, not the council. Pins then said, on the 1st of September, well, the inquiry is going to be opened. And the council didn't respond to Mr. Telford and the appellant until after Pins had said. So what Mr. Hardy said, and I repeat no criticism, is factually wrong. It wasn't the council refused to postpone. Pins had already said that the inquiry would go ahead.
Did I not? I just forgive me if I'm wrong, but normally before I make a decision on that, I do seek the views of the other side. Did I not ask you, the council, for a view before I made that decision on postponement?
I don't.
That's what I would normally do. But
Perhaps you do, but perhaps I'm wrong.
There may have been a
but
response, an initial response saying the inquiry is fixed for whatever. But I believe that before I said no to a postponement, I asked what you thought about it. I sort of recall you saying that you didn't want a postponement in very general terms. That's I recall.
The council was obviously very sympathetic to Mr. Telford's circumstances, but in light of the fact that the date had been set, all parties had been informed, all the room bookings and everything had gone ahead, we invited the inspector to modify the inquiry to a virtual event where everybody could attend remotely. One of Mr. Telford's reasons was that he wouldn't be able to travel 4 hours from his home in the Lake District. So we felt that a virtual inquiry would facilitate his attendance at it. So the virtual inquiry was offered, and then we received notification from Pins that the meeting would sit and he will be able to make his representations at that time.
Thank you, sir. Forgive me. It's a complex web of emails, some of which I wasn't party to. They are set out in the appendices to the cost application. But in any event, the council was in a difficult position, whilst being sympathetic to Mr. Telford's circumstances of dealing with Mr. Telford on a range of other matters, but on this particular matter, absolutely no engagement, no proofs, no agreed statement of common ground, nothing. And then needing to instruct council for an inquiry and the other costs that go with an inquiry. And it wasn't the case, so as I remember, you will know this better, it wasn't agreed from in advance that it was going to be a case management hearing. That was mooted as a possibility by you, that it could be used as a case management hearing.
So I wasn't saying this is not going to be an inquiry, but it was one of those factors that even if it couldn't go ahead, there could be some value. Just to backtrack a little bit, what you said about the council having had engagement with Mr. Telford on other matters, I don't think I can really even take account of that because I didn't have evidence of it. It's actually Mr. Telford's not here to respond to that. So I heard what you said, but in all honesty, I'm not going to.
Well, it was a response made it was a point made in response to.
I know, but if I'm not going to say, oh, well, actually, I don't believe that Mr. Telford wasn't able to deal with this matter because he was dealing with the council on other matters. I don't think I can.
No,
it's
a detail, but in any event, and unfortunately, many of us would have been in this same difficult experience or similar difficult experience. This is an event which had gone on for several months, and the council, I think, initially sought the advice from PINS, or what do you do? I think it's the first time I'd been in an inquiry where just no proofs have been submitted. PINS made clear that the inquiry
lived.
Sorry,
I said you haven't lived.
Yeah. So the council was obliged to go ahead and prepare fully for an inquiry. It wasn't that the inquiry was downgraded to a case management hearing in September. It was required to instruct council and to prepare for a 2-day inquiry. And so I'll just turn to my side. Just to check. Nothing further. Thank you.
Thank you very much indeed. And I said yesterday that I often look forward to closing submissions, but I'm often disappointed. Well, I wasn't disappointed today. They're both very helpful sets of submissions, and thank you to everybody for your contributions throughout the inquiry. It has made my job easier. I had sort of hinted yesterday at the woes and travails of being an inspector in terms of timescales and so on. What I can say is that I always try to get my decisions out as quickly as possible, because actually nobody wants that more than me. I like to get things resolved as quickly as possible. But there are certain obstacles in the way. One is that I had sort of back-to-back hearings just over a week ago, which I've got to finish the decisions on those. I've got a rather complicated hearing resuming in a couple of weeks time. And I've got all my management duties plus Christmas in the way. So it will be longer than normal for me, but that's not to say it will be a long time. That's very vague, isn't it? But I can't be more specific than that. Anyway, thank you all very much indeed. Unless there is anything else, the inquiry is now closed.